Hello, everyone. Welcome to the U.S. Immigration News. In a time when the rules of immigration feel like they change by the week, when policies get stricter, discretion gets wider, and the system feels harder to trust, a stunning decision just came from the highest court in the country. In not one but two major rulings, the U.S. Supreme Court has stepped in to remind the government and the nation that due process is not optional. Even more surprising, these rulings came from a court with multiple justices appointed by President Trump himself. And yet, in a clear constitutional voice, they ruled in favor of fairness, justice, and immigrant protections. These cases don't just affect Venezuelan migrants or asylum seekers. They set new legal firewalls for millions, including green card holders, students, TPS recipients, and those facing removal. In this video, we'll break down exactly what the Supreme Court said, what it means for green card holders and immigrants alike, and why this may be the most important legal victory for immigrants in years. If you are liking this video, please hit the bell button, subscribe, and like it so that you may get updates straight to your smartphone. Now let's get into the video. It started on May 16th, in a case involving Venezuelan migrants in Texas. The Supreme Court ruled that the federal government cannot detain or deport someone without giving them a clear reason and the opportunity to respond in court. It wasn't just a symbolic win. It was a reaffirmation of one of the oldest principles in American law, the right to due process. The decision centered around a concept known as habeas corpus. Translated from Latin, it means bring out the body. In legal terms, it's the right of every person to challenge unlawful detention. It ensures that no one, citizen or non-citizen, can be quietly removed from the country without explanation, without warning, and without a fair hearing. And the court didn't just rule narrowly on one case. It sent a message. The justices wrote in plain and powerful language that no person shall be removed from the United States without opportunity at some time to be heard. That one sentence has the potential to reshape how deportations are handled across the country. For years now, immigration enforcement, especially under the Trump administration, has leaned heavily on executive power. Programs rooted in emergency wartime laws like the Alien Enemies Act have been used to fast-track deportations. Immigrants from countries facing political instability or civil unrest have been labeled security concerns, sometimes without clear evidence. In some cases, people have been removed to third countries, places they've never lived or even visited, within a matter of hours. There have been reports of deportations carried out with less than 12 hours' notice, without access to legal counsel, and in some disturbing cases, without even the chance to notify family. But now the Supreme Court has drawn a line. In a 7-2 decision, the court instructed the Fifth Circuit Court of Appeals to review whether the Alien Enemies Act actually applies in today's context. And significantly, 3 justices appointed by Trump sided with the majority. That bipartisan agreement suggests the court saw something deeper than politics. It saw a constitutional issue. The rulings are also forcing courts to define what sufficient notice actually means. What kind of warning must the government provide before deporting someone? How much time must be given? What kind of access to legal resources must be provided? While these cases began with Venezuelan migrants, the ripple effect will be much wider. Because when the court makes a constitutional decision, it sets precedent. That means these principles will begin to apply across the board, including to green card holders, asylum applicants, and even those on temporary visas. If you hold a green card, this could be a quiet, life-saving shift. Until now, green card status was no guarantee against sudden removal, especially if someone had faced arrest, charges, or simply gotten caught in the web of enforcement discretion. Under older interpretations of immigration law, someone could be detained or placed in removal proceedings, even without a conviction. But with these rulings, the court has clarified that even lawful permanent residents must be given notice and the opportunity to be heard. This doesn't mean green card holders are immune to deportation. But it does mean the government can't act in secret. They can't pick you up and send you out without offering a real chance to respond. If you are ever detained or placed in proceedings, you now have constitutional support to fight back, and that matters. Immigration attorneys across the country are already calling this a turning point. It may not immediately stop all removals, but it gives legal teams the tools they've long needed. In cases where someone is facing deportation due to a criminal charge or past arrest, having an unresolved appeal or even an open legal question may now be enough to delay or halt removal until due process is fully followed. The impact it isn't only legal, it's deeply human. In recent years, there's been a chilling rise in so-called disappearing migrants, people picked up by ICE and quietly transferred, often without paper trails, to distant detention centers or foreign countries. In some cases, individuals have been sent to war zones or politically unstable nations where they had no family, no history, and no way to survive. The government has often cited national security as justification. But the court in these rulings is saying something different. It's saying that national security doesn't override the Constitution. That even in times of fear or political tension, rights cannot be ignored. The next phase will be crucial. The Fifth Circuit must now define what qualifies as a fair warning. That definition, once finalized, could become a standard applied in every immigration court in America. If the lower courts hold the line, ICE and CBP may be forced to reform how they handle detention and deportation cases. And this ruling goes beyond procedure. It strikes at the heart of unchecked enforcement. It sends a message to DHS, to ICE, and to the Trump administration: you are not above the Constitution. You can enforce immigration law, but you must do it transparently, lawfully, and with respect for human dignity. So, what should you take away from this as a green card holder, or someone who's undocumented, or waiting on asylum or TPS or any other kind of status? The first takeaway is simple but powerful. You have rights. No matter your status, you are entitled to receive notice before being removed. You must be given time to prepare. You are allowed to ask for a hearing and to defend yourself. If you are detained, ask to speak with an immigration attorney, not just a public defender. Make sure you understand the charges being brought against you. And don't assume that the government is acting lawfully just because they're in uniform. These rulings prove that even the government needs to be checked. And there's another important lesson here. Carry your documentation, but be cautious. Some attorneys now advise avoiding carrying foreign passports or documents that identify your nationality unless absolutely necessary. In some cases, law enforcement has used these documents to build cases for removal, especially in areas with aggressive ICE presence. But most importantly, don't let fear win. The system can feel stacked. The rules can feel overwhelming. But this moment, these Supreme Court decisions, are proof that legal protections still matter. That even in a tough immigration climate, the Constitution still speaks. That's all we have in this video. The US Immigration News Channel provides all necessary visa information and procedures for your US immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about US visitor visas, such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. If you haven't already, please subscribe to the US Immigration News Channel. Thank you for watching, and we'll see you in the next video. This script